quite compelling, concrete, and common to the work of all of us, access to justice. And for that reason, I think that there are reasons to remain intense and passionate in our discussion about this reality. So, access to justice is surely not a new theme, and I would already challenge us in our capacity to go beyond the obvious, because there's no country in the world that can really claim that they got it right. And the common problems that we would find in this region would probably be equally relevant to most regions of the world when it comes to how the system overall is friendly, is adapted, is accountable to children. But surely there are specific realities in this region, in Africa, in Eastern and Southern Africa, that are worth examining together. Beyond just having a general discussion on access to justice, it is important to look at the specificities of the realities of child victims of sexual exploitation. It's not just any witness or victim that are coming forward, but because of the complex and sensitive reality around sexual exploitation, access to justice is even more critical. There's even more sort of parameters for safeguarding, for accountability that should be in place. Unfortunately, we're not up to the challenge, let's say. And it begs the question sometimes as to, is it fair to refer children and put so much emphasis towards reporting when we can't ensure that the children are put in a process that is actually going to bring positive outcome for them and for the society overall. And there aren't a lot of alternatives to that, but this is important to look at it critically, to bridge also informal justice systems with the formal realities as well, looking at the official procedures and the services that are supposed to accompany those proceedings and processes. Luckily, with ECPAT, we have been involved in 13 countries to collect voices of survivors in a format of conversation. We're particularly proud of that because we tend to focus a lot on collecting experiences of victims when they're adults, because of sometimes fair concerns about the ethics, the methodology, the risk of re-victimization. But sometimes it's also comforting to deny the right of participation to those children just because it's a little too complicated for us. And the voices of young and adult survivors is certainly valuable, critical. And for that, we must commend movements like the Brave movement and others who are really now putting this at the center of so many location of conversation, decision-making processes to really change the narrative and bring those voices forward. At the same time, it's not but, it's at the same time, let's not forget that the voices of children themselves is also important. And when you do engage with them meaningfully, in a safe manner, you do get access to a lot of information that is really challenging the way we frame our services, our approach, our policies, our legal mechanisms. Many times it's not so much that the information they provide is so new, but the articulation of it is so concrete that it really brings another edge to the ability to advocate for changes. And in this very region, I believe that we have involved children in Namibia, in Kenya, there's been also in Malaysia and Cambodia as part of Disrupting Harm, where voices of girls and sometimes as well boys have been collected and are telling us, after all the analysis we made of Disrupting Harm, for instance, that what they concretely experienced was just clearly not up to the standard. That we failed in many little spaces that do not actually require money. It's about attitude. It's about the words we choose. It's about the way we welcome their testimonies. And it's a challenge sometimes we tend to forget. Yesterday we spoke a lot about funding. And of course, ECPAT is all about receiving more money. That's fine. You don't hesitate if you want to make donations. But there's so much we can do without resources as well. So really looking at it from the point of view of children, for me, was quite humbling to say there's a lot we can do that is not about creating fancy infrastructures and building new sort of systems in place. It's just about making sure that our overall approach to children is illustrated in this very special moment where children might come forward and reveal that they've experienced sexual exploitation, and how we're going to approach this and basically do what we, be accountable and be responsible for providing services that are adapted to them. And the reality is that even in the north, in my country, in Canada, we have much to do there. So it's not necessarily a conversation about poor and rich countries or Africa versus the rest of the world. It's a common global challenge. Hopefully the next 2 days we'll be able to unpack not next day, today, sorry, my God, I want you to stay for longer. Today, yeah. We'll try to focus on really adding a value to the existing narrative. We have to commend organizations like Defense for Children, Penal Reform International, Terre des Hommes, UNICEF, who have been really leading for a long period of time the issue of justice with children, access to justice. There are a lot of tools out there. There are a lot of training material. There are a lot of standards. When you try to list all the guidelines and minimum rules in the UN systems, there are some that are specific for Africa. We've done a lot of work collectively to work on norms and standards, on capacity building exercises, on material for awareness raising. Yet, what the children are telling us is they don't see much the impact of it. So let's be demanding in our conversation about going beyond the obvious and not just, go in our zone of comfort and reiterating the work that we keep doing, which does not necessarily make a difference as far as we could hear. That's a bit challenging, but I think that's worthwhile to really spend time today and focus our energies on this. We've been lucky to get support in addition to Disrupting Harm with the Global Partnership, UNICEF, Interpol's collaboration, and all the organizations that contributed to Disrupting Harm, to also secure a partnership with Bread for the World, this German organization. I think that many of you are also in your country collaborating with them. And through them, we've put an emphasis on a certain number of countries that include 3 in this very region: South Africa, Uganda, and Kenya. We analyzed the legislation, the policies when it comes to access to justice for children. But more importantly, we had workshops with practitioners to really look at the specificity of the trajectory of child victims of sexual exploitation and survivors, and see what are the bottlenecks and how the system is geared towards adapting to those specific realities. And that informs reports, and each country has done an advocacy roadmap, looking at how they can target a few critical aspects where they believe a difference can be made. Sometimes we get sworn by the overwhelming number of flaws in our systems, and it can be a bit discouraging. But if you target a few elements where we believe with few resources we can make a difference and bringing it down to earth, then maybe it can be motivating to try to continue pushing for better systems accountable to children. So we'll hear from those 3 countries that have made that analysis and that journey of mobilization and see what has been those conclusions, hopefully as a way to generate an open discussion as we've had so far in the past 2 days. We'll also embark with a conversation with experts and people who are daily working in the justice system and see how they see today's challenges and good practices and promising elements that are existing in the system. And we'll conclude the day for a more sort of open space of discussion about what to do, what should we focus on for the way forward together on those matters. That's the program for today. Just that. So, allow me to introduce first Mr. Théophane Nikiyema, a rock star in Africa. So he's from Burkina Faso. You might know him because of his long career with UNDP and the UN system, and especially also with the African Child Policy Forum. Today, he's part of the African Committee of Experts on Charter on Rights and Welfare of the Child and Special Rapporteur on Justice for Children. So you see the connection? We're smart, right? Yeah. So he made it during the night, and so with 5 cups of coffee today, he's really sharp and will help us to sort of listen to the conversation. He will moderate a session this afternoon, and at the end of today, we'll hear his views on what you've heard today. Thank you for being with us. And now I'll pass the baton to Honorable Charity Aluosh, who is the Chief Magistrate and Head of Children's Court in Kenya, so that she can make, and I'm speaking slowly, so that is there something? No? Is she on her way? Yes?
She's coming, but you will need to repeat what you have said for her so that she will.
The introduction of her?
So that she understands.
Ah, so you want me to repeat all of that? The problem is it's going to be different. Confusing. Okay. So, repetition sometimes is pedagogical. Or should I ask you, what did you understand? So she's downstairs, she's making her way up, so let's give her a few moments. So far, is that the conversation, has it been sort of up to your expectation when devoting the time to join us so far? What's the energy level? Not too bad? Not too bad? All right. There's a few, but a few silent faces as well. How is Portuguese at the back? Is it okay? It's okay. Yeah? Good. I think also it's worth mentioning for our conversation today, those of you who have not seen, Mama Fatima is the special rapporteur on the sale of children, sexual exploitation, and child sexual abuse material at the UN system. And she presented to the Human Rights Council in March her annual report, which focused on compensation. And I think it's a worthwhile reading. It's not so long, but it's a good overview of the situation globally. It would certainly echo the realities of this very region. So that's a recent overview, but it can be a nice instrument for advocacy as well in your respective countries. So I really encourage you to focus on your attention on this one. Her next report to the General Assembly, this time in New York in October, will be on voluntarism. So she's collecting right now last few pieces of information to pay attention to this reality, which is often a little bit neglected in the context of travel and tourism. But all of us, the NGO sectors, as much as religious organization, peacekeeping mission, it can be a faith-based organization who deploy personnel, well, not personnel, who recruit basically people without necessarily checking the backgrounds and sending them sometimes to orphanages, to primary schools, to locations where children are active. And in many instances, it can lead to a harmful situation. The Better Care Network has done a brilliant job in examining the trends, especially in Africa, on how orphanages and institutions are often interlinked with context of voluntarism. There's been some promising practices in the countries where the travelers are coming from, oftentimes, especially in Europe, to alter the offer, because it is now a trend in travel and tourism to look for additional purposes behind option. And you see, therefore, a trend in volume of people going more to location where they interact with children. From the point of view of children, massively, all the studies have demonstrated, it's not making sense at all to have people coming and going all the time, taking photos with them, and then leaving. And it gives access to people who might have ill intention, or people who came with good intention, but because of the situation ended up abusing children. All that to say, that's the focus of our next report. So quite interesting and worthwhile to pay attention to this. And in this region, we tend to neglect that sector, not feeling that it's so relevant, although in reality, it's very much present. So let's be careful at that. And meanwhile, I'll start again. Just saying, basically, today's focus is on access to justice, as we said. And this is an opportunity to bridge our conversation yesterday on disrupting harm, online sexual exploitation, the voices of children, and seeing how we can elevate the conversation on overall having a child-friendly justice system, but especially looking at the distinct dynamics around sexual exploitation that demand more scrutiny, more accountability in our systems. So that's the agenda for today. And it means that I have the honor, the pleasure of introducing Honorable Charity Aluosh, who is Chief Magistrate and Head of Children's Court in Kenya, to make the opening remark. Thank you very much. Do you prefer microphone like this? Or, yeah?
Good morning. I heard the introduction that I'm head of the children's courts in Kenya. I'm actually not. Years ago, under the now repealed Children Act 2001. So I'm glad to be here. Now, my boss, the Chief Justice, usually says she comes from a community where they greet twice. So I'll say good morning twice, just like her. So good morning, and then she goes good morning again. Thank you. So this is her speech. It is an honor and privilege to address you today at this regional workshop on sharing experiences and lessons learned in combating sexual exploitation of children in East and Southern Africa. I commend the organizers of this workshop, ECPAT International and Kenya Alliance for Advancement of Children, or CACT, for bringing together civil society organizations, working together in solidarity to end all forms of sexual exploitation of children. This includes the sexual exploitation of children in prostitution, sale, and trafficking of children for sexual purposes, online child sexual exploitation, and sexual exploitation of children in travel and tourism. These are grave violations of human rights and dignity that affect millions of children worldwide, especially in our region. I am keenly aware of the challenges and opportunities that we face in ensuring access to justice for children who are victims or at risk of sexual exploitation. Access to justice is a fundamental right enshrined in our Constitution, which also recognizes the rights of children as a vulnerable group that requires special protection. In addition, in 2022, Kenya enacted one of the most progressive children's legislations in the world in the form of the Children Act 2022. Moreover, Kenya, like most of the countries in the region, has also ratified the Convention on the Rights of the Child, or the CRC, and the African Charter on the Rights and Welfare of the Child, with the aim of bolstering the protection of the rights of children, including through prevention and combating sexual exploitation of children. However, putting in place child-friendly laws is not enough to protect our children. We need to ensure that our courts are accessible, child-friendly, gender-sensitive, and responsive to the needs and the best interests of children. We need to ensure that our judicial officers are trained and equipped with the necessary knowledge and skills to handle cases involving sexual exploitation of children. We need to ensure that our courts work in collaboration with other actors, such as law enforcement agencies, social workers, health professionals, civil society organizations, and communities to provide holistic and integrated services to children. When I came to the office as the Chief Justice of our great nation of Kenya, I committed to establish a judiciary that is responsive to the justice needs of our people, especially the vulnerable groups. From my many years working as a judge and thereafter as the chairperson of the Special Task Force on Children Matters, it became clear to me that our justice system was not responsive to the needs of children in contact with the law and in conflict with the law. This despite the fact that a justice needs survey conducted in Kenya in 2017 established that 5% of legal problems are legal problems related to children. Ladies and gentlemen, it is for this reason that through the Kenya Judiciary Strategic Vision that we call social transformation through access to justice, or in short, STAJ, we are committed to pursuing an agenda of opening the doors of justice to all by tackling the formal, informal, and systemic barriers to access to justice. We are working towards ensuring access to justice to all, especially the vulnerable groups such as children and victims of sexual and gender-based violence. We are therefore keen on tackling the great paradox that faces our justice system, which is that those who are in the greatest need of justice are the ones who are excluded from the justice system. To this end, my office has developed the Child Justice and Sexual and Gender-Based Violence Strategies, which we will launch on 26th of June this year. A key pillar of our STAJ, Child Justice Strategy, that we will be launching in June is the rollout of tailor-made courts throughout the country, beyond the existing ones, that is Tononoka and Milimani Law Courts. Milimani Law Courts is a specialized court for children, and also Tononoka. So there are only two in the country that are specialized. Now, nevertheless, even before the launch of these strategies, the judiciary is already championing the protection of the rights of children through various processes and systems. Allow me to mention some of them. One of the ways the judiciary in Kenya is able to facilitate and implement access to justice for children is through the National Council on Administration of Justice, also known as NCAJ in short, which is a multi-stakeholder body whose focus is to strengthen coordination and reforms in the justice sector and improve administration of justice in Kenya. The impact of NCAJ has been revolutionary. This has been enabled by the fact that its work is cascaded and decentralized to the grassroots at each court station through the court user committees. We also call them CUC. The heads of the justice agencies sitting at the helm of the council receive reports from the CUCs which inform policy direction and resource allocation towards administration of justice. As a country, we are now moving towards establishing CUCs that handle specific issues, including children matters. In this regard, we are working on progressively establishing separate children court user committees to ensure collaboration and coordination of efforts geared towards tackling bottlenecks and systemic problems that hinder the efficiency and effectiveness of a child justice system. The NCAJ, Standing Committee on the Administration and Access to Justice for Children, is another game-changing avenue towards justice for children. The Standing Committee is comprised of different child justice stakeholders from different institutions. These include what we call the ODPP, or the Office of Director of Public Prosecutions, the National Police Service, the judiciary, non-governmental organizations, prisons, probation, Department of Children's Services, and members of the academia. Now, the Standing Committee is mandated to address gaps regarding the administration of justice for children, and in turn, provide legislative, policy, procedural, and practice direction reforms, survey and compile data on all matters of children, and provide a platform for ease of coordination of all actors in the child justice system. Continuing with the work of a previous task force, one of the key successes of the Standing Committee lies in transforming attitudes and practices through inspiring positive changes in the way child justice institutions conduct their business. Key examples is the development of practice directions and standard operating procedures to guide the handling of children by the police, the Office of Department of Public Prosecutions, and the judiciary. The robust advocacy by the committee has also led to the establishment of children specialized units by justice agencies. Ladies and gentlemen, one of the gaps that impede efficient delivery of justice in Kenya is backlog of cases in the judiciary. We discover that children in contact with the law are hindered from accessing justice by the delay in their matters. It is for this reason that the judiciary has designed November as a National Service Month on Children Matters. On this month, all the courts in Kenya are mandated to prioritize children matters and push towards conclusion of these matters, as well as sensitize the community on children issues. The service months, which are mostly themed, advance the concept that children belong in school and not in the court corridors. This practice has since been institutionalized and has been a great game changer as the court user committees come together and rally around addressing the issues of children from the court to the community. During service month, various tools are put in place to expedite the cases, including plea bargaining, diversion, mediation, and ensuring that all children are represented. Success has been recorded over time, especially in reducing the number of cases and also bringing the judiciary to the community we serve and reducing the fear that people have towards the justice system. These are some of the initiatives that the Kenya judiciary has been undertaking to deepen access to justice of children in Kenya, including those who are victims or at risk of sexual exploitation. However, we are also aware of the challenges and the gaps that still exist. We are committed to addressing them through continuous reforms and innovations in collaboration with our partners and stakeholders in the justice sector and beyond. Ladies and gentlemen, as we gather here today to share our experiences and lessons learned in combating sexual exploitation of children in East and Southern Africa, I urge you to reflect on how we can strengthen our collective efforts to end this scourge. Sexual exploitation of children is not only a violation of their rights, but also a threat to their development, well-being, and potential. It undermines the values and principles that we cherish as a society. It requires a concerted and coordinated response from all of us, governments, judiciaries, law enforcement agencies, civil society organizations, communities, families, and children themselves. I hope that this workshop will provide us with an opportunity to learn from each other's best practices and challenges, to identify gaps and opportunities for collaboration, and come up with concrete recommendations and action plans for the way forward. I look forward to hearing your insights and perspectives on this important topic. However, we also acknowledge that we cannot do this alone. We need to work together with our counterparts in the region to share our experiences and lessons learned, to learn from each other's best practices and challenges, to identify gaps and opportunities for collaboration, and to come up with concrete recommendations and action plans for the way forward. Sexual exploitation of children is a transnational problem that requires a transnational solution. It affects not only our individual countries, but also our regional stability, security, and development. It calls for a concerted and coordinated response from all of us, that is governments, judiciaries, law enforcement agencies, civil society organizations, communities, families, and children themselves. That is why I commend ECPAT International for undertaking these two projects focused on disrupting harm and access to justice. These projects are instrumental in generating evidence-based research that will inform and influence advocacy and interventions on various aspects of combating sexual exploitation of children within the Eastern and South Africa region. To conclude, I hope that this workshop will provide participants with an opportunity to exchange ideas and perspectives on how we can enhance our efforts to end sexual exploitation of children in our region. I hope that it will inspire us to think creatively and strategically about how we can leverage our strengths and resources to address this scourge. I hope that it will motivate us to act decisively and urgently to protect our children from this menace. With those remarks, it is now my singular honor and privilege to declare this regional workshop officially open. Thank you for your attention.
Thank you, Honorable Charity. Let's give her a better clap. I think she's... Thank you, thank you. Those were really wise words, and I think the whole issue of collective effort is key. We are so grateful, and I think in the same vein, I know that you are pressed for time, you need to go to court, but we are really making a request that you just allow us, the panel that is going to come less than an hour, to go through the same issues that we've been talking about and just people sharing from other countries that have been doing access to justice. Then I'm sure by exactly 10, we'll be able to release you. We actually want to take a picture with you, so that's why we're requesting when you go back home, we'll be so grateful. So at this time, I want to welcome our next moderator, Mrs. Irene Ndegwa, who is a pro bono lawyer, and Claire Feller, to invite her panel as quickly as we can. We are late by like 15 minutes, so we'll do less than 15 minutes also, so that we can be able to do this session. Karibu.
Good morning, everyone, once again. My name is Irene Ndegwa, and I have the singular pleasure to be able to moderate this session coming up. If I may have my panelists, Madam Anna Nabulia, Madam Edith Krill, and Madam Joy Katunge, please join me. Ladies, karibuni sana. If we may begin by maybe taking a round of introductions and also introducing your organization, starting with Anna, please. No, just. Yeah, just.
Good morning, ladies and gentlemen. My name is Anna Nabulia. I work with Uganda Youth Development Link as a Deputy Director, and UDEL is a member of ECPAT.
Good morning. My name is Joy Katunge Matheka. I work for Kenya Alliance for the Advancement of Children in Nairobi as a legal officer.
Good morning, everyone. Edith Krill from Jelly Beans in Cape Town, South Africa. I'm the Executive Director for Jelly Beans and a social worker by profession.
Thank you very much to our panelists. Now, today we are here to talk mostly about your work with regards to A to J, okay? And from yesterday, we've been having a lot of conversations, and as we've been informed, we do not want to be able to rehash what has been talked about in terms of the challenges. Today, we're going to be looking at the strategies and the solutions that each of your country has been able to employ so that we can be able to share and, be able to strengthen our knowledge thereof. So we want to be able to go directly and find out with regards to the issue of the legal framework in each of your countries, okay? So that maybe you can talk specifically with regards to your own legal framework. Has there been any evolution in terms of that particular issue to be able to address children with regards to sexual exploitation? Anna?
Thank you. Yes, with regards to the legislation in Uganda, there has been some advancements that have been made in Uganda. Right now, our legislation caters for children and has processes, especially in the ODPP, that are sensitive to children. However, we still have a few gaps in our legislation, especially when it comes to supporting children access compensation, and also in the referral pathway. We still have gaps in the referral pathway because we do not have a clear guide on how survivors or children can be referred for other holistic services. And I think we also still have an issue to do with the triage kind of system where we can provide holistic services. And we also still have challenges to do with reporting. I know yesterday we were talking about DH and children not reporting cases of violence or exploitation against them, but also within our legislation system, we do not have a clear reporting structure. Yes, we do have some sketchy plans for reporting. For example, we do have the 116, which I think is in most of the East African countries. We have UNICEF that has the U report. However, some of these platforms are still not known by many of the children, but also the UNICEF U report platform is more English. So that means that the children that cannot speak English in Uganda will not be able to access justice, which will be a problem. And then also, we are still finding challenges with making our system child-friendly. Yes, there are sketchy plans that are in place. For example, I know in ODPP, we do have child-friendly rooms that have been established. However, these are only 11 rooms that have been established in 11 districts, and Uganda has close to 157 districts, and I think they keep growing every other day. So it becomes a challenge to access justice for children. So I think we need to expedite that process of having child-friendly rooms. And then we also still have just one officer, regional child officer in every court that can handle aspects of children. So we have one person in each district handling children's matters, which is quite a big caseload for this one person. So I think our legislation is still very weak in that aspect, but also supporting victims access compensation. Thank you.
Thank you so much, Irene, for that question. I'm going to give a Kenyan response to the issue of legal framework. We recently enacted the Children Act in 2022, July. So the Children Act has come in and repealed the 2001 Act, which had we had identified several gaps that have now been addressed. So in terms of progression in our legislation, I'd say that yes, we've made a huge milestone. And just to note that in the current Act, the Children Act of 2022, it addresses things that were of concern to us as practitioners, specifically on SEC. For example, we have a definition of what online abuse is, grooming, and for me that is a big step towards the right direction. Still on the Children Act, it talks about child-friendly courts, which has been a topic of discussion for the last 2 for some and 3 for others days. And there's a provision in law that the courts need to be child-friendly, and even goes ahead to explain how this can be done. Of course, we have gaps in implementation, but regulations are underway. We have the task under the NCJ that has just been mentioned by Honorable Aloch. We have the NCJ, then there's a task force for children. So they're developing regulations that will look into the details of how this act will better be of benefit to children. On survivors, child survivors of SEC are covered for, not only in the Children Act, which I'll keep emphasizing because it's a very new legislation, but we have the Witness Protection Act and the Victim Protection Act that categorically goes to mention children as vulnerable persons who need protection. Still on legislation, we have the case management guidelines that give the details of how a child abuse, child exploitation case should be handled from A to Z. Of course, the challenges of implementation still remain, and also dissemination. In past forums, I've interacted with people, and they say, yeah, we hear about them, but we've never had anyone come to tell us about the case management guidelines. A good document that has been, in my opinion, shelved. Children in contact with the law are offered pro bono legal representation in the Kenyan courts, stipulated in the Children Act of 2022, as well as the Legal Aid Act. Then lastly, because there's much that I could mention, but this I felt were the most important, the same Children Act of 2022 provides that every police station should be having a CPU, a child protection unit, to hold children. So generally speaking, there's been a lot of development, positive progression in the legal framework and provisions for children in our Kenyan laws. Thank you.
I think in terms of our legal framework in South Africa, we have exceptionally good legislation, well thought through legislation, very comprehensive legislation, and I think is often seen as, you know, a good case study for other countries. The difficulty, as I think with many of the countries here, is in terms of our implementation. So I think in terms of the legal framework as such, you know, we've got things in place. I think the one thing that I do just also want to comment on, and I'm not sure if we're going to get a chance to speak about it as well, is, you know, when we're talking about legal frameworks and the concept of justice, I am also very thoughtful that we think of justice as a very binary concept, in that justice is what a conviction is. So if we have a conviction, then we have justice, and that's really how we see justice currently. And I'm so thoughtful of the majority of children, if we use that way, that lens of looking at justice, the majority of our children will never receive justice. So we have to, I think, also start thinking about what is justice? Is justice potentially a child being able to disclose and being believed by their family or their community and being protected? Is that potentially, is that justice? Is that something that we should see as a win on behalf of the child? Or do we want to continue to see the criminal justice process as the only way of measuring justice? And for me, that takes away the possibility of giving children opportunities to really feel that they have some justice, because the criminal justice system will never and can never deal with all of the cases. And in particular, I think in terms of online sexual abuse, which adds another layer of complexity in terms of evidence, I think, you know, it makes it really, really difficult for children to get justice. So I'd like to challenge us all to start thinking about what is justice when we think about children. In terms of what Anna has mentioned already, was also looking at reporting and referral pathways. So we know that we need to have children get psychosocial support while going through criminal justice processes. But what we're not seeing, and I think which would be really helpful, is to start being able to track reported cases. So they are reported, but there's no accountability or there's no follow-up. So once I've reported it, I don't know what happens to that child. I can't track what happens to that child unless I particularly specifically follow up with them. There's no system in place to track children and to ensure then that children don't fall through the cracks, because so many of our children do. An issue that came up in the Access to Justice conversations also was around the issue of compensation. So what was really interesting, and it's something that's also been alluded to in conversations here, is the traditional African practice of restitution in terms of paying of damages, if I can use that word in inverted commas. So, you know, that there's a way in terms of which families negotiate a way of restituting when there's been sexual abuse. And the conversation that sort of erupted as a result of access to justice in South Africa is, if we are talking about compensation, are we not in some way, we're talking about compensation fund, are we not in some way mixing some of the messaging that comes with the practice of paying for damages? So in other words, there is a concern that if we have compensation for children who are being sexually abused, are we not looking at this being a way of using money to deal with the problem? And who also will be responsible for paying of that? What would be the criteria? Which children would be able to access such a fund? You know, what would the fund look like? Who'd be responsible for the fund? So the issue of compensation has brought up quite a lot of kind of contentious issues, which I think has sparked conversation, which I think is really, really interesting. But in essence, at the end of our Access to Justice conversations, it was suggested that compensation at this point in time is not the primary, or shouldn't be the top priority. There are so many other things that we need to get in place before we start looking at an issue of a compensation fund. I'm sure there's lots of thoughts out there on this issue. Just two other things, or three other things, was also looking at the police. Sorry, I'm losing sound here. Do you have another? Thank you.
Sorry about that.
Being thoughtful, thank you. Being thoughtful of that the police is the entry place most of the time to child protection issues and sexual abuse issues, and that our general police officers are not trained, not equipped, not skilled. And in response to trying to deal with this, something that's spectacularly put egg on everybody's faces is some of the police stations now have a big desk that says gender-based violence desk. So you can go and report gender-based violence at that desk. You know, the intention was good, but the execution was a spectacular fail. We still have a long way to go in terms of helping children with special needs in our justice system. I think a challenge for all of us. Also thinking about children who commit offences. So we talked a lot about, you know, that peers are often the ones who are extorting and blackmailing other peers in terms of online sexual abuse. And how do we deal with those peers, the under 18s, in terms of our legal system? And then also just again, the issue of psychosocial services.
Okay, thank you very much. We have a lot to unpack, obviously, but let me just give one last round of questions because I know time, we have about 10 minutes left. I want to be able to look at this issue of, again, strategies and solutions, and I want to be able to break down these barriers into two. Okay, so barriers to entering the justice system, and then barriers once in the system, because we've actually been dealing with both, just interchangeably. So once you enter the justice system, there's the issue of reporting. There's the issue of children being invisible. What it means is this: does a child have the right to be rescued? Okay. So that what happens is, what are the mechanisms with regards to rescuing a child? Is it a children officer or is it the police? And then, of course, the issue of a child feeling like a criminal. I think we usually have that issue with regards to, as you're saying, if it is a child who sent another photo, are they going to be willing to enter that system? So that there are going to be those barriers to enter in the system. Then once in the system, there are also those barriers of, do we give the child therapy and time to recover? Meaning, is there pressure to prosecute in terms of the child victim? Are they given time to recover? If that particular violence has emanated from the home, we usually rescue the child, isn't it? Take them to another home. Is there then the right to support from the family? Because what happens is that for some of us, I do a lot of pro bono work in terms of even victims, they're taken to a children's home for the duration of a trial. And let me be honest with you, defilement cases take 3 to 4 years to conclude. What do you do then? There is also the issue with regards to their safety. Now they're in the system. How what strategies can you share in terms of their safety? The trial process is going to be a lot to unpack, but I just want you to be able maybe to deal with the issue of what mechanisms are put in terms of their safety when they're testifying, the networks which are available, isn't it? Whether it is the witness box, etc. There's also going to be the issue of re-victimization in courts. How do we deal with that? Does a child have the right to be informed of what is happening in court? Or is that going to be a process that is going to be too complex for that particular child? And of course, as always, the remedy, as Edith has pointed out. Apart from compensation, we're also looking at the issue of reintegration. Sometimes we have to look at that being a remedy. Is that, what remedy do we have in terms of their recovery? I know that's a lot to unpack, but take what you can, and then maybe hopefully we are able to open the floor for discussions. And of course, we would obviously want to be able to hear from the Chief Magistrate. Asante. Anne?
Sorry, I've been requested to stand because I think at the back they can't see us. I don't know, is this better? Okay, I'll start from the aspect of the barriers when they get into the system, and of course, the barriers to reintegration and recovery. I know the law is a little bit silent on the recovery and reintegration, but it just does, I think the victim-centered guidelines do provide for this in Uganda. However, I think the challenges is mainly where to refer, who to refer to, the capacities of the people that you're referring to, but also the feedback process. And when it comes to the reintegration component, it's largely managed by the civil society in Uganda. The government does not have reintegration and rehabilitation centers, so it's quite difficult for you to make a holistic referral pathway or reintegration and recovery pathway in a situation where you're working with mainly civil society manning the rehabilitation and reintegration centers. And of course, the challenges with civil society handling this, because they are running projects which are basically short-term, and many times may not have the required resources to provide the holistic service. So this is where I think our Ugandan government is making headway in the multi-sectoral approach, where they try to work with a number of partners to come and support the process of reintegration. But I feel that Uganda needs to commit to at least reintegration services that are run by the government themselves. Yes, we can go through the probation officers, we can go through some of the children's committees that have been set up, but also these do not have funding or do not have required personnel, or the personnel that are there are not competent enough to be able to handle cases of sexual exploitation of children. And I think they need more awareness, they need more trauma-informed trainings, because sometimes, especially in police, you find interviews are being handled in large rooms where you're talking to where you find an officer is talking to a child here, and as they are speaking to the child, they're bringing in another person who is an offender, and they're arresting another person. There's this thing happening. Everyone is asking what is happening with that case. So the privacy is a little bit difficult at police. I know with the ODPP, it's a little bit better with the child-friendly rooms that they have created. And I think also with the child-friendly rooms that we have seen in ODPP, they allow for children to enact out what has happened and not just talk about it. So it's easier for you to they have these doors within these rooms that children can use, but I think also sometimes it may be re-traumatizing to enact out what happened to you for the child. And of course in court you are supposed to use certain languages for the private parts, and they want the child to say or to show them that particular private part, which is a little bit sensitive in our cultural setting, so that can also be a hindrance for children opening up. In terms of safety, there have been some little mileage that has been gotten in Uganda. I know right now in police we do have a transitional shelter that can at least accommodate 10 children at a time. But I think, again, this is just a transitional shelter, and it's very limited space, and it's only at the headquarters. So the other police stations do not have this, and it's quite difficult, but they also lack some necessities like food that could be needed urgently by the children or medical care. In terms of re-victimization, that is likely to happen. Like I showcased the situation in police where everybody's walking in and, trying to ask the child what is happening. Before you know, the media is also out there trying to glamorize this child. Before you know, you have all these NGOs coming in and also trying to support the child. There's a lot of re-victimization because sometimes the cases are not treated sensitively, but also because sometimes the duty bearers have not been trained in sensitive care. And especially I'll point out the media. They'll just put the faces of the child. This is the child who has been defiled. This is the child who has been sexually abused out there for everyone to see, without minding their privacy, without minding the other aspects of their safety. So sometimes it's a little bit difficult. And of course, we do not have a witness protection policy, which becomes very difficult for witnesses to come out and talk about certain aspects of the case or to commit to being witnesses in a particular in a particular case because they are not sure of their safety. I think I'll stop there. Thank you.
Thank you, Irene, and beautiful remarks from my fellow panelists. So I'll start first with the issue on reporting. And just like in her country, we have the 116, which is a national toll-free number that children and adults, concerned adults, can report any issues concerning children. So that is one of the reporting platforms that we have working in Kenya, accessible from the 47 counties that we have. The other reporting platform is, of course, the police. We're still having efforts from the CSOs trying to build the capacity of police, and more specifically the gender desk. We have what we call the gender desk in Kenya, where we have trained personnel handling gender-based issues as well as child protection connected concerns. So that's at the police. Not all of them have trained personnel or even have a gender desk, but at least they can talk about most of them having that. Kenya has 47 counties, and in the 47 counties, we have sub-counties within the counties. So in each sub-county, we have a children officer. This is a government officer that has an office situated within the sub-county where you can walk in physically, because it's a physical office, and make a report and get support services. And we also have the CSOs that do the bulk of the receiving of cases and follow-up, and especially the cases of criminal nature. Not only criminal nature, but the ones that need to get to court are basically or mostly those of criminal nature. Then we have the Fichua kwa DCI. Fichua in English is disclose. So we have a number called, it's a long number, not easy to remember, like 116, but we had a number known as Fichua kwa DCI, where you can just disclose any criminal issue, including child protection concerns, SEC, to the DCI, that is the Directorate of Criminal Investigation. Then on matters of visibility, coming from a community or a society where children are to be seen and not to be heard, we are slowly moving away from that. And looking in the context of the courts, the justice system, for children who are in conflict with the law is clear that they need legal representation. They are deserving of legal representation at the cost of the state. So the state provides a pro bono lawyer to support this child. I've had instances where I've had to support in civil cases. So I know there's CSOs like FIDA, there's CAC, through the Law Society, the branches, and even the national office. We have these lawyers who volunteer their services to support cases as long as they're children cases, vulnerable persons. Then still on visibility, our law provides for intermediaries. An intermediary is more like a vessel, someone who will help the child communicate to the court to the child. So we have a provision of intermediaries just to ensure that the child is very well heard, seen, represented. Then on criminalizing the child, all children are children in need of care and protection. So whether they come in conflict with the law, contact with the law, we regard them as children in need of care and protection. And that means that as long as you're under 18, you still need that care and protection. So it goes to show us that we are really moving away from stigmatizing them just because they committed some offenses. Then the Children Act that I had made reference to, 2022, talks about diversion. It really emphasizes on diversion, on children cases, just to ensure that children do not enter the criminal justice system. This was being done before the Children Act of 2022, but it was heavily vested with the ODPP. The prosecutors were literally doing it all. But now under the Children Act, the new Children Act, we have the stakeholders in the justice system play a part. So at the onset, we have the court, we have the prosecutor, we have the investigating officer who is the police, and even the lawyer who's representing the child. They are making these decisions and reports about the scene. Then lastly, when handling a child's case, we do not use their real names. For example, if the child is Joy Katunge Matheka, you won't find a name, a file with the name Joy Katunge. We abbreviate just to protect the child's dignity, privacy, and all. All this go towards dealing with the stigma and criminalizing a child. PSS, psychosocial support, has been offered. Of course, it's costly. We're not at a place in Kenya where we can say everyone can access it. But it's being offered. And the court has been acceptive and receptive of play and art therapy, where instead of having to describe the things that you are saying are taboo in our society, a child can just draw, a child can use Play-Doh and sort of model whatever they're trying to explain to the court. They can use other means instead of literally saying what happened. The courts have been receptive to that. PSS psychosocial support is also offered by 116. We have trained counselors who offer support to these children free of charge, as well as volunteers. We have practitioners, professionals who offer their services for free to the courts. Then in Kenya, we're moving away from institutionalizing children. We are progressively embracing the institutionalization. So unless there's a very good and compelling reason why a child needs to be taken to a CCI, a child needs to be removed to a home, we are really keen on supporting, protecting the child from the family setup, because home is the best place for a child to thrive. So that is what I have to say about that.
Thank you. I'm thoughtful that the minutes are ticking by, so I'm going to be very brief. I think our biggest barrier, we have two biggest barriers in terms of entering the justice system. People have lost faith in the justice system. And second of all, children and families are very wary if they do enter the justice system. As one child says to me, every time I go to court, they open the scar and I bleed all over again. And, you know, the justice system has a job to do, to consult, etc., but from a child's perspective, it's a very painful process. And even if we have intermediaries, child-friendly rooms, making use of anatomically correct dolls, there's no way around it but to say that children will experience traumatization going through court, doesn't matter how awesome the system may be. And I think in terms of that, we need to keep in mind that preparing children for court, keeping children informed of what's going on in their cases is critical. And I think often is where we lack significantly. Families and children are not informed in terms of what's happening with their cases, don't understand all the technical aspects of their cases, and that there's no one specifically, I kind of want to say appointed, or whose responsibility it is to be that liaison person. Everybody thinks it belongs to someone else. And then also just to say that child-friendly rooms, another mic, can you hear me? Child-friendly rooms have a very valuable place, but need to be continuously ensured that they're maintained, that the CCTV, etc., is working, so that those things that are meant to be there to help children don't become another obstacle. What is interesting in our country, though, is also we have the ability for children to testify from another space. So in our law, if we look at the letter of the law, it would allow children to actually be able to testify via Zoom. But we're not making efficient use of that at this point in time. We still think that children have to go into the special courtroom and use the CCTV system there. But actually our law allows for a lot more bigger scope. And hopefully with COVID and with all the things we've learned with COVID, with online work, that we're going to be able to start really pushing that issue. If a child can testify from Childline's offices via a Zoom space, would that not enable them to be a much better witness? Thank you.
Thank you very
To our panelists, thank you very much. But before we conclude, we want to be able to hear from Honorable Charity Aluoch and find out, are there any strategies or solutions you would wish to share with us, please?
Thank you very much. And Irene, by the way, was my classmate in college. And I think that's why she's bullying me, like she is. Okay, nothing much really. Joy has covered quite a lot, but let me just add my voice to a few of the issues you raised. The psychosocial support for the children. I know it's a big challenge, but we have partnered with civil society organizations that provide this service. We do not have any attached to our courts. But because of the partnership, we are able to get these services. Apparently, children officers are not, some of them are not trained therapists, so they're not able to help much. But we at least recommend the places we can refer these children to. Victim protection, we try. At least we have legislation on this. We have the witness protection boxes. But what I have observed with this is actually we do not put children in those witness protection boxes. We put the perpetrators. Why? Because we need to observe the demeanor of these children as they give evidence. Well, in some cases, we're able to put them in those witness protection boxes, and it really helps. The re-victimization of children, it is real. But we're having discussions, I don't know if there's anyone from ODPP here, on using pre-recorded statements, so that they don't have to tell the story again in court. But then they will still have to talk. Why? Because they have to be subjected to cross-examination by advocates who represent the suspects or the accused persons. But of course, we train these pro bono lawyers. We have training supported by our partners. so that, they can do it in a child-friendly way, in a way that this child is not re-victimized. Now, the child protection units, yes, we do have, and at least we have trained officers who man these child protection units at the police stations. But the problem is that they are not specialized. They handle many other cases: robbery, violence, murder, all manner of criminal investigations. So I hope one day, someday, we will have officers who just deal with these cases so that, they are not mixed up. And again, the spaces they work from, most of our police stations do not have child-friendly spaces. Yeah, what they have is just a desk that they're used by many other officers to handle other cases. I hope we are going to have better services in the future. But I know that we have what we call the polycare in one of the police stations in Nairobi. The idea is to have all services at one place. You have a counselor, you have a children officer, a probation officer at a police station. We hope that this is going to be rolled out to other parts of the country. Reintegration, we get a lot of support from the Department of Children's Services in at least ensuring that these children are reintegrated. But the biggest challenge we have now is an emerging issue, the child trafficking cases from neighboring countries. I don't know if there's anyone from Tanzania here. Allow me to mention your country, that we are receiving a lot of these children that are being used. Apparently, some are relatives using them to beg in the streets. They're actually children without disability, but they pass as children with special needs, disability. They're used to beg. Some of them, at least, police have arrested the suspects. But I realize that it's an intricate syndicate. It's not easy to crack it. But the ones that have been brought to us, we have been able to deal with. The problem is reintegrating and repatriating. How do you ensure that they are safe back in their countries when we return them there? Of course, we celebrate the new act. It has brought in a lot of changes, especially for children in conflict with the law. The assessment that is required to be done. You see, so that we are able to see whether that is a child that can benefit from diversion or rehabilitation and can be taken out of the child justice system, which is actually very lengthy. And of course, we support pro bono lawyers. We are the ones, the judiciary is the one that manages the fund. So actually, we have the pro bono lawyers register, we train them, and we pay them. I think that is all I can say for now. There's a lot we can say on this issue. I wish I had more time. Thank you for giving me the opportunity.
Thank you very much, Honorable Alwoch. And I believe I've been given permission to open the floor for 2-3 people. Then we go for our photo session. I don't know how to pick. So.
Actually, Timothy, this tells you this session should have been given more time. It's, yes. My name is McBain. I come from Malawi, and this one I'm specifically asking to the justice system. Thanks for acknowledging that we have serious issues when it comes to deferment cases. I would want just to understand why it should take so long to get a deferment case, because this is a nightmare. We just repatriated a 14-year-old who has been in the same home for 12 months. And sadly, 2 days after repatriation, the suspect reappeared, when we were told the suspect has disappeared to Zimbabwe. So these are realities, and the question I have to the justice system is, why do they take long? Is there a special issue that we need to address? Thank you.
Thank you, McBain. Maybe we'll take them, then we can respond together.
Good morning. One quick question. It relates to the role of social workers in the different procedures. Can you describe at which stage and which role they have in the judicial procedure? Thank you.
We'll not ask somebody to ask a question but make a comment later. Would that be okay? Yeah, but I know you're from the prosecution.
Can I be next, please?
Okay.
Thank you very much. Yeah, it's fine, as long as I feel time to speak. I'm Celeste Fieres, Child Protection Specialist from UNICEF, Namibia. I would like to hear from Kenya. You mentioned that your Children's Act is passed, but that the regulations is not out yet. So what are you doing in the interim on OXIA? Because I know in Namibia, our Children's Act made provision for the production of child pornography, but it failed to penalize the possession and the distribution of material, and that's why we have a very big challenge in Namibia, because we would like to have a comprehensive legislation that is looking into the criminalization of everything, you know, and not only in production of the of the material. My second question is children in contact with the law. I would like to find out whether it is based on a restorative justice approach, and what is your age of criminal responsibility?
Thank you very much. Yeah.
Okay. Okay. Thank you so very much for giving me. It's not a question for me. It's a comment. He's saying that I need to make the comment short, right? No, I'll try to make the comment short. That's one comment that I was thinking when you are presenting is all about law and courts, right? But for me, as a child protection professional, it seems that my experience shows that justice is actually not done only in court. So there are some backward linkages and forward linkages. If you don't put this into perspective, that's why, you know, you can say that as UNICEF people, you always talk about the system, child protection system, but there's a reason why you talk about that. And, you know, if you don't bring in other people, it's not only about police, it's not only about magistrates, judiciary, prosecution. We need to talk about social welfare system, where, as my colleague from UNICEF Madagascar was asking about the social worker, where is that? You need to put that into perspective. If child is not, it's not about legal assistance or legal aid, the support that child needs, be it in conflict with the law or contact with the law. Somebody has to take the child through the system, to navigate the system, and that all pieces have to be together. One piece without the other will never work. So when we talk about justice, we talk about those different part or pieces of the system. Thank you.
Thank you very much.
Yes, thank you. Good morning. My name is Stanley Mtuma from Judiciary in the Office of the Chief Registrar. So I have two comments and a question. The first question would be the issue of safe houses. I've not heard the panelists speak about the issue of safe houses, and I do understand that when the trial process is ongoing, these children need to be in protected zones, because you'll find out that in some instances, the offender or the perpetrator is someone they could be living with. So it would be very difficult to see how the child could give proper testimony, yet they are going back to the same environment where the offense were being perpetrated. Then the second comment is that I would like to know what the panelists think about the issue of monitoring and surveillance of convicted sexual offenders. In this instance, I have in mind, like the Kenyan jurisdiction and South Africa, we have the Sexual Offenders Register, which also falls under my docket, under the Office of the Chief Registrar. And in this register, we have details of all convicted offenders, mainly for purposes of monitoring and surveillance of these offenders once they are out. So thank you.
I have the mic.
Thank you very much. I'm not giving you a chance to speak. Let's do this, then you'll speak after Mweni.
Thank you so much for these opportunities. For me, I'm going to bring the voices of children in this conversation, okay? A month ago, we had the African Children's Summit, and I'm going to read what the kids said. give us opportunity and educate us about our rights so that we can know when our rights are being violated. Okay? I'm just reading from what they have said. And this is very, you can see, looking for someone from Department of Children's Services in Kenya, I can't see, but a report by DCS 2 years ago showed that most children do not know that they are being, okay, I think I'm talking now. I'm saying most children don't know they are being violated, and so they do not report, okay? Especially issues to do with sexual violence. They don't know their rights. They do not know if you touch me, this is actually a violation. So, and one of the things kids are saying, we are all legalese here. Language, okay, the language that we use is very complex. Are we able to simplify some of these terms that we are talking about? Thank you so much, Tim. Some of the terms that we are using to very simplified language that children can be able to understand. Actually, this is violation, okay? This is what sexual abuse looks like. Because you know what sexual abuse has been defined for a long time is penetration, okay? Even online sexual abuse is not abuse to some children. So as I'm bringing the voices of children here, can we be able to simplify this? Let the children know that this is our rights and this is how violation looks like. Thank you very much.
Second last, and then we have a response. We'll go for T.
My question is, my name is Florence Mweni. I'm a probation officer. My question is to Joy and maybe to the magistrate from the judiciary. We have court-annexed mediation. There is an over-reliance on counselors as volunteers and interns from universities who are still doing their counseling, so they don't complete the sessions. Is it possible, do you see a possibility of Kenya having court-annexed psychological counseling services so that courts are able to not struggle looking for a counselor or a psychologist, and they get the professional services that they need? That's one. Question number two, and South Africa has talked about, Zoom sessions, court sessions. I did a study as part of my doctoral, and some of the things that children were saying is that just seeing the perpetrator on camera makes them forget and get scared of even giving the evidence because the perpetrator is facing them. According to them, the perpetrator is actually looking at them. So what safeguards are there, even as we do those Zoom court hearings, to even protect the child from getting threatened by attending that kind of session, which is supposed to even be better than physical appearance? Thank you.
Yeah, thank you very much. My name is Joshua Ongwe from Child Fund. And I go back to what the colleague from South Africa said. It's about corruption and compensation. There's a perception that when you go to court, you may not get the justice. So, and the perpetrators, from the lessons we've had, are relatives, a brother, a father, a community member and such. So how do we address cases where, like we've seen, where such things happen, then the parents happen to collude with the perpetrators? They're given some money because normally the perpetrators are rich. They're likely to be richer and people in power, so that they withdraw the case from court, like out of court. Like there's an abuse, you are given 5,000 shillings, and then you just say, by the time I go to court for 3 or 4 years, it is too much for me. So how can we address such a case? Then the second one, on online child sexual exploitation and abuse, is there an experience where someone is accused, like in another country, and the child is in another country and there should be repatriation? Or is there just in such a case in real sense? How does that happen if there's someone with an experience on the same, on OXIA? Thank you.
Madam Chairperson, I'm Rogers Kasile from Uganda. We've been pointing a lot of fingers towards the justice system and the way courts and procedures are going. But also I want us to have a self-reflection as social workers and NGOs and CSOs. It appears we're a mixture of workforce, probably who are pointing so much at the justice system. I want us to have a self-reflection. Do we have the capacity ourselves to understand and appreciate issues of justice? Because many of us are coming from different fields. and probably we are not so conversant with the issues and the procedures. In other words, this is an area which ECPAT and networks should take on to build the capacity of people who are going to interface with courts, with the court system and judiciary, so that we are up to speed about what's going on, instead of pointing so much and blaming and identifying gaps and identifying challenges. But we ourselves, are we up to speed? Thank you very much.
Thank you. We have a session after tea break. I think there'll be a continuation of the same discussion. That's why Madam Samadi said she'll rather respond at that time. But I think let's just be able to give a little response to those issues, then we can go for tea. We are getting a bit late.
So from my perspective, I just want to comment on the social workers' role, and thank you very much to the colleague there that spoke about the role of social workers in the child protection field. You know, it's easy to point fingers at the justice system. I think the difference is sometimes the way that we perceive things. As social workers, we deal with a lot of fuzzy grey stuff, where the justice system deals with black and white. You know, there's facts, they work in facts and evidence, and a lot of times social workers, we don't necessarily work only in that kind of space. So we do need to understand where the justice system is coming from, and we do need to reflect on our own services and poor and lack of services. In terms of the role of social workers, from a South African point of view, there's really sort of two main focuses. The one would be the statutory role, and that would be to ensure the protection of children, the safety of children, the removal of children if needs be, the placement of children into alternative care, and the reintegration of children should it be safe to go back home, which in our country is always, you know, like Joyce said, home is the place where we want children to be. So the social workers play an exceptionally important role in the protection of children. Also in terms of case management, that often lands on the desk of the social worker, being the liaison between the child protection and the criminal justice and the mental health aspects of the work that needs to happen. Providing assessments both for courts in terms of are children ready to testify, where should children be testifying, in the main courtroom, in special courtrooms, you know, doing forensic assessments in terms of that. Providing court preparation for children, advocating on the rights of, and you know, on behalf of children to ensure that justice does happen, and then a huge component also in terms of providing mental health services to children and families from when the cases get reported right through until we can graduate children out of the therapy system, whether it be because the criminal justice process is finished, or whether it be because children are ready to carry on with their lives and to, you know, close, or I don't want to say close, that chapter 1 can never close a chapter on sexual abuse, but that it doesn't continue to determine a child's life every day going forward. Thank you.
I'll handle a couple of questions that were directly addressed to me, but I'll begin with the one on why does the case have to be super slow. Of course, I'll seek your support, Honorable Aluoch. So, in our context, Kenya, for example, it's an adversarial system. So evidence has to be heard, and you know, a case has to go through the whole process of court. You cannot just say that someone is guilty at the onset just because you believe that they are guilty. The due process of the law has to take place, and this can't just take place in one day. Courts sometimes are slow because of the backlog. Some courts are understaffed, and hence at the end of the day we say that maybe children cases are not being given priority, but there are other cases that are also being handled that may be needing such quick handling to be handled expeditiously. So that is just partially. I'm sure you have a better response to that question. On OXIA, what we are doing now that it is covered under the law, but we do not have the regulations. One thing that you have to appreciate, and it has been said before, is that OXIA doesn't happen in isolation. You can't be talking about offline and online like they're two different animals. It's one side of the coin. It's just the same thing. And technology will forever be ahead of the law. The law just comes to address social injustices. So we are trying to play a catch-up game. So in our context, Kenya, yes, we have it now, but before we were relying on the Computer Misuse and Cybercrimes Act, I think Section 24. It talks about child pornography, which we prefer to call CSAM, child sexual abuse material. So we had other legislations that I wouldn't say sufficiently, but we have other legislations that we can look at. The Computer Misuse and Cybercrimes Act, we have the Data Protection Act, and even our Sexual Offences Act thoroughly talks about sexual offenses against a child and talks about child pornography as well. So yes, we have other laws that we can also rely on for the same, but not in much detail and specificity, as the Children Act talks about or online abuse of children in a child-specific legislation, because the Children Act is basically the Bible when it comes to matters children. The age of criminal responsibility is currently 12. Initially we were at 8, but to the new, we still call our constitution new, 2010 new, so I don't know how our Children Act 2022, that must be very new. We are at 12 years. That criminal responsibility is at 12 years. Then safe houses, she's going to talk about that. Role of social workers has been handled. Reporting when. Yes, this has been brought up in, if you look at the DH reports, it has come out severally that reporting is an issue, and children do not exist in a vacuum. Children belong to homes, families, spaces. So I take it upon all of us. We have a role in sensitizing the people we live around, if it's in the church, if it's in your office spaces. Whatever you know and you think everyone knows, you'll realize that you hold something that the other person does not know. So just remember that, yes, we need to simplify, we need to have popular versions of these acts, child-friendly versions, but if we do not have those resources, does it mean that we won't cascade this information? Definitely not. So we have to use what we have to just ensure that what needs to be done is done. I think that is it from the questions. The one that was asked by my senior, Mr. Stanley, about monitoring and surveillance of convicted sexual offenders. I know we're in the process of automating our sex offenders register, and this is where it's coming from. I think it's something that as a country, Kenya, we need to really follow through, because we could be here pushing through and ensuring that children have access to justice in the best way we understand. We support them, the cases are reported, they get to court, the prosecutors are supportive, they understand, they go before Honorable Eloch, and the case is handled perfectly. But we could be churning the same criminals back to the community, reoffending, and we do not have systems or any means of just knowing where is this convicted offender 5 years later, or even a month later. Once they are released, I think that is just it. They come back to the community, and we really do not know what they're doing. The law is clear about where they can't work with vulnerable persons like children in schools, but really, how much have we gone to make sure that this is happening? So I heard your voice, but I couldn't see you, so wherever you're sitting, my take is that yes, it's something that we really need to follow through to ensure that surveillance and monitoring of convicted offenders is done. Thank you.
Thank you, Irene. I know we are pressed by time, but I'll quickly talk about the safe houses and the protected zones. And I think we made comments about this earlier, where we're saying we're making slow steps. And in Uganda, I think most of the safe houses are run by civil society. But there's something, there's a pinch of salt in the ocean. And of course, we've also started with seeing the police having that transitional shelter. It's one at the CID headquarters, which can have their capacity of 10 children at a time. It's slow steps there, but we will get there one day. And I know also that the child-friendly zones are also supportive in providing protective zones for children while they're in court. So thank you.
It's a quick one. Just in connection with the question around Zoom, or online meetings, in a similar way to how we would protect children if they are physically in a special courtroom, they wouldn't be seeing the perpetrators. In a similar way, it would be with Zoom. They would be sitting with the intermediary, and they wouldn't be seeing the people in the actual courtroom, because of course that would be defeating the purpose if they are seeing the offender. So it would not be that the child would be seeing all the people in the courtroom, but it would be that the court could be seeing the child and the intermediary.
Thank you very much. The next session will be a continuation of what we've begun today morning. I want us to take time to appreciate our panelists. Round of applause. And thank you very much for your time. Asanteni sana. I want to hand back to Tim. Thank you.
She has done a wonderful job, and I'm sure that I think the whole of today we are dealing with A to J. So let us be geared to continue listening to. I want to call Mama J to make a vote of thanks to our guest as he's leaving. Mama J is from Tanzania. You said there are many children from Tanzania, so there are many people from Tanzania here, but she's a senior mama. She's been a regional coordinator, and I think she's the best person just to pass a vote of thanks. Maybe you just come forward if you can, please.
Karibu, nitaongea Kiswahili maanake ndio lugha ya sisi Waswahili, alafu nitatafsiri kwa Kizungu. Tunashukuru sana kwa kuja kwa serikali ya Kenya kwa kutupokea sisi wote wajumbe wa Exploitation International, lakini pia tunashukuru wenzetu wa CAR kwa kuhakikisha wameandaa kitu kizuri. Kwa hiyo tunakupa zawadi ndogo lakini ni kubwa kwa kumbusho kwamba huu mkutano umefanikiwa sana, kwa sababu tumeongea mambo mengi sana ya kuhakikisha tunapambana na ujambazi wa mtandao kwa watoto wadogo. Karibu sana. Naomba upokee. This is a small gift to Charity Oroch because she's representing the government of Kenya, and as ECPAT members, and on behalf of the ECPAT International and CAR, we are so much pleased to have her today, this morning, but also to have a commitment of the Kenyan government and the judicial system to support the online child sexual exploitation. Thank you so much.
Thank you very much. You did it so well and very exact. So I want us to break for a group photo down very fast. I'm sure we are running late. Let us all walk down to where we took our picture. We take a picture with the Honorable Charity. Maybe you can have a chat with her. It's raining. So where do we take the picture from? Behind this. Okay. Will we fit all of us? Maybe Guillaume, give us some direction. Yeah, I'm lost.
We are NGOs, we're creative. We'll find something, don't worry. a bit the expertise and the presentation that have been made by our three excellent panelists, divide in group, and speak for an hour and a half about access to justice and the ideas that already emerged but needs a bit more sort of time to see what we do really about it. May I urge you to look at it from the point of view of children, not from the point of view of the justice system. So it means we're talking about access, children's access to justice. So the emphasis is on the children, not the justice aspect. So with all of our knowledge and experience, what have we learned? What are the good practices? Sometimes what are the bad practices? How can we really sort of try and instill sometimes bold ideas? There were some challenges posed by the presenters on maybe how we need to revisit our approach entirely. So this is our chance, having an hour and a half of conversation about those elements. What we suggest is maybe that we can use Uganda to come forward with Anna and Thomas, I believe, to be in lead of that discussion. And that would be at the front of this room. At the back of this room, we should have a conversation with Edith, and is it with Sandrine, I think, on South Africa. Exactly. Nasty. And at the base floor, in the room that we've used yesterday, then we'll have Kenya together with Joy and Willie. Now, let's take into account that there are a lot of people from Kenya in the room, right? A strange invasion that happened somehow. So, I would actually encourage the Kenyan not necessarily to go to the conversation on Kenya. It'd be more interesting to spread across and go and use the opportunity to learn more about Uganda and learn more about South Africa. So I'm kind of tempted to let you go to one of those three. But of course, if we realize that everyone goes to the same, then I'll be a dictator and sort of force. And it's an excuse, right? Having South Africa, Uganda, and Kenya to maybe initiate a discussion. Thank you. Woo. But all ideas are relevant, and it's an equal conversation. So we can talk about all sorts of examples from other countries and ideas that emerge. All right? So an hour and a half staying in your group with the startup of being either Uganda, Kenya, and South Africa, but then let's expand the conversation. Would that make sense? So make a decision as to where you go. Don't be lazy, those at the back, to stay at the back just because it's convenient, right? Just challenge yourself, go to maybe the countries you know least, so that also generates a bit of learning in that sense. So I repeat, Uganda here, South Africa at the back, and downstairs we have Kenya. All right? Have fun, and see you around lunch.